Welcome back, folks, and we're on to Chapter 12, The Judiciary. And here are learning outcomes for the week. We'll identify the sources of American law, including constitutions, statutes and regulations, and the common law tradition. We'll define the rule of four process. We'll outline the structure of the federal court system. We'll analyze the pros and cons of how federal judges are selected. And we'll define judicial restraint and judicial activism. Sources of law in the United States. Well, as you might guess, the most fundamental foundational law or laws that we have in the United States is in the U.S. Constitution. This lays out the structure of government and the Bill of Rights and all the things we've been exploring to this time. We also have state constitutions, and state constitutions do things similarly, but at the state level. Obviously, they cannot be in conflict with the United States Constitution, but they lay out the structure of government and rights and privileges and basic laws at the state level. There is case law. This is essentially judge-made law or common law, precedent, legal decisions that have already been made. And of course, those must be in line with the U.S. Constitution when it comes to the federal court system, or when it's in the state court system, they have to be in line both with state constitutions and the federal Constitution. We've got statutes and administrative regulations, and we've explored both of those in the past. Statutes are laws that are made by Congress or made by state legislatures, and again, they cannot be in violation of the United States Constitution. And there are those regulations that are made by our federal bureaucracies and our federal agencies, and that was what we discussed when we went into the executive branch and the federal bureaucracy. Also, when the United States or when the president negotiates a treaty with another country and that treaty is ratified by the Senate, that also becomes the law of the land. So that's another form of American law. Spend a little bit more time with the common law tradition. As you know, the United States was once a British colony, and so our legal system is derived from the British system. And the British system to this day is based on legal customs and precedent. In fact, the United Kingdom doesn't have a constitution. It has, centuries of common law, centuries of legal custom. So common law or case law, this is judge-made law. This is looking at previous decisions to inform a current decision so that judges are not making decisions all over the place. And this creates stability within a legal system, especially in the British situation where they don't actually have a written constitution. So precedent, this is a court ruling based on previous judicial decisions. This is looking at how previous cases were decided, particularly from higher level courts, and using those to inform the decisions of lower level courts. We refer to this process as stare decisis, Latin for let the decision stand, and again, looking at previous cases to guide how decisions are made. Now, we do know there are examples of when precedent is reversed, like Brown versus Board of Education overturning Plessy v. Ferguson. So there are those situations when clearly a law or decisions are perhaps not in line with the Constitution or other competing laws. But if precedent is reversed too often, you have a lot less stability in a legal system. So this is the benefit of the common law tradition. We don't tend to see precedent overturned very frequently. And if we did, there would be much less stability when it came to our federal court system. The majority of court cases, may they be lawsuits or criminal trials, are happening at the state level. And state laws are impacting us more on a day-to-day basis. So most people will not have business before a federal court. There's some reasons for this. First of all, there's the matter of jurisdiction. If a case is going to be considered in a federal court, there needs to be a federal question, something that relates to federal law or the Constitution. Or there needs to be a diversity of citizenship issue where you have people, citizens of different states, who are going to a federal court because a state court wouldn't be appropriate. Or you have a matter that involves a foreign national, and that would need to be handled perhaps in a federal court. You also need standing to sue. There needs to be a controversy that's justiciable. And what that means is the court is not going to deal with theoretical issues. The litigants or the litigant, is going to need to be able to demonstrate that they were impacted by perhaps a law that's in question. It cannot just simply be a matter of theory or challenging an existing law. There needs to be something solid where someone can demonstrate that they were impacted by perhaps an unconstitutional regulation or law or government practice or whatever. There are multiple parties to lawsuits. Of course, there's the litigants themselves. There's the plaintiff who perhaps brings the lawsuit or brings the lawsuit. There's the defendant who is obviously defending themselves. But also, you could have interest groups or corporations or individuals who might file what's called an amicus brief. And this is a friend of the court brief. This is an argument on one of the litigants' behalf. And also, you could have a number of litigants in a class action suit. That is, people who have a similar problem. Perhaps it's related to a pharmaceutical that had bad consequences for people who took it. They might band together and file a class action lawsuit on behalf of that group of people. Here's a diagram of the three-tiered court structure, the federal court structure that we see in the United States. I'll talk about this in the slides to come. And by the way, this is very similar to how the Minnesota court system is structured, which was based on our federal court structure. So as I said, we have a three-tiered federal court structure. And at the lowest level, there are trial courts. These could be either general or limited jurisdiction courts, which means general, they would kind of handle a variety of criminal and civil suits. And limited jurisdiction would be focused in one area, like a tax court. Those levels above it are appellate courts. So if someone believes that their case was tried incorrectly, and that the law was not properly applied, they can appeal to a higher level court. The next tier there is the Court of Appeals, and then above that is the United States Supreme Court, which in most cases is also a court of appeals with some very limited exceptions to that. Again, when people appeal to an appellate court, they're not getting a retrial. New facts are not considered. Additional witnesses are not called. The judges on the appellate courts, the justices on the Supreme Court, are going to look and see whether or not the law and precedent was applied correctly, whether or not the Constitution or other federal laws were violated, that sort of thing. We also have a federal FISA court, which deals with matter of national security, and it conducts its business in secret. Primarily, it's hearing requests for warrants to gather information on individuals. As it was created, this court was to gather information on individuals that were suspected spies or suspected of spying and were foreign nationals. But after 9/11, this was expanded rather dramatically by the Patriot Act to gather information much more broadly and including on American citizens. And this continues to be a point of controversy today. Here's an overview of the courts of appeal in the United States. And as you can see, a single court of appeal will cover many states. And there's not a single judge that helms that court of appeal. In most cases, it's a three-judge panel that will determine whether or not a lower level federal case was decided properly within the law. Again, they're not dealing with matters of fact. They're dealing with whether or not the law was correctly applied. Okay, let's narrow our focus to the Supreme Court at this point. Many are surprised that an individual does not have a right to have their case heard by the Supreme Court. A tiny fraction of a percent of cases that are seeking review in the United States Supreme Court are actually heard. So most people who seek to appeal their case to the Supreme Court are not successful. And in that case, the highest level court that is considered the case, that stands. So if their case made it to an appeals court, a federal appeals court, then their decision will stand. Now, As I said, the vast majority of cases that are appealed to the Supreme Court are not heard, they're not reviewed. And it's entirely within their prerogative to determine whether or not they will grant a petition for review. If 4 of the justices agree that the case should be considered by the Supreme Court, they will issue what's called a writ of certiorari, and that basically is saying, send the case our way, we're going to hear it. 4 of the justices have to agree to hear a case. So that is what we refer to as the rule of 4. At that point, a case is scheduled before the U.S. Supreme Court. This is 9 justices, and they will hear limited oral arguments from both sides. Again, this is not a retrial. This is a question of law. This is not a question of fact in the court cases. Was federal law, was the Constitution applied correctly in this lower level case? Well, as I stated, people do not have a right to have their case heard by the Supreme Court. It is a subjective process. 4 of the members of the court have to agree to issue a writ of certiorari and have the case sent up to the United States Supreme Court. But here are some factors that increase a case's chance. When 2 lower courts are in disagreement, we can't have 2 federal courts ruling on the same issue in different ways. So in that situation, the Supreme Court's more likely to take it. When a lower court's ruling conflicts with an existing Supreme Court ruling. When a case has broad significance, so these are big issues of the reproductive rights, right to die issues, freedom of speech, religious freedom issues. These are much more likely to be heard by the United States Supreme Court. When a state court has decided a federal question, the Supreme Court is more likely to hear it. When the highest state court holds a federal law invalid, that'd be something that would be much more likely to be heard by the Supreme Court. When a federal court holds an act of Congress unconstitutional, that in most cases is going to go before the United States Supreme Court. An example from a few years ago was when lower courts and courts of appeal were declaring parts of the Affordable Care Act, aka Obamacare, unconstitutional. When those lower courts were disagreeing and holding that act of Congress as unconstitutional, it was just simply a matter of time until the Supreme Court had to take up whether or not the Affordable Care Act was constitutional. When the Solicitor General was pressuring the court to hear a case, the Solicitor General is a Justice Department employee that works for the President of the United States, and it's their responsibility to represent the President of the United States, represent the federal government, the White House, before the Supreme Court. When the Solicitor General is pressuring the court to hear a case, they're much more likely to hear a case. And in many cases, too, Solicitor General is a stepping stone to serving on the Supreme Court. In some ways, the way the Supreme Court makes decisions is mysterious because the deliberation between the justices, this happens in private. But in other ways, the court decisions and opinions are very clear because they write their detailed legal reasoning for why they decided what they decided. And so in this way, they provide a lot more insight to their thinking than we would see in the other branches of government. Now, a decision is obviously the decision of a majority of the court, but other opinions are written as well. In many cases, those who are in the minority of the court, those who don't win the argument of the day among the Supreme Court, they may issue a minority opinion. So we see that, or a dissenting opinion. The decisions that come down from the Supreme Court will fall into the following areas. They could affirm a lower court ruling, that is, that the lower court decided things correctly and interpreted the Constitution correctly within the opinion of the United States Supreme Court. The court could reverse the lower level decision, say, no, it was decided incorrectly and the lower court's decision is reversed. Or it could just simply provide some clarification on the law, remand or kick the decision back to the lower court to reconsider in light of the legal clarification that the Supreme Court has provided. The types of opinions that you see come down from the court are unanimous. You probably know what this means, right? The entire court agrees. So 9 members of the Supreme Court agree. And this happens quite a bit, more than we might think. We talk about those matters before the Supreme Court that are highly divisive, highly controversial, but in many cases, the members of the Supreme Court agree on the details of the law and they issue a unanimous opinion. In other cases, the majority will win. So if you've got a 9-court majority, anytime there's 5 in the majority, they'll carry the day. The majority opinion is written by those justices who are in the majority. The Chief Justice gets to assign who writes that opinion if they're in the majority. If they're not in the majority, the longest serving, the most senior justice gets to decide who writes the opinion. And again, you could see a 5-4 majority, you could see a 6-3, and so on. Now, sometimes you'll have people who are justices who are in the majority. They agree on what the outcome should be, but they disagree on their legal reasoning. And in those situations, you might see a concurring opinion where there are, again, 2 justices on the Supreme Court who agree, but they agree for different reasons. Sometimes you will see a plurality decision. That is that no group of justices is able to persuade the other justices to join a majority opinion. So you might have 3 or 4 that agree on the legal reasoning, and they'll write a plurality opinion, and they could have some concurring opinions that will help them come to a decision, but for different legal reasoning. So sometimes plurality decisions or decisions that don't reflect the majority will carry the day. And then we also see dissenting opinions, especially on those big cases that are dealing with reproductive rights, or they're dealing with freedom of speech or freedom of religion, or the big issues of the day. Those justices that aren't in the majority may choose still to write a dissenting opinion. And this makes a lot of sense in those really close decisions that are 5-4, because it could simply be that the difference of one judge in the future could change a minority or a dissenting opinion into the majority opinion. So they're going to take the time to lay out their legal reasoning. And in many cases, dissenting opinions could form the basis for a majority opinion in the future. The Supreme Court begins its term the first Monday in October, and their work continues through July in most cases. So it's about 8 months a year, not a bad gig if you can get it. The big decisions, the most, cases of the most significant consequences, those decisions tend to be issued right at the end of their term, right before they go on vacation. And the rest of us are discussing the controversies that come from them. Those decisions tend to be issued in late June or early July. As you know, the president appoints and the Senate must confirm all judges to all levels of the federal courts, and they serve for life. So it's a pretty important responsibility. There's a great deal of permanence to the judiciary. It used to be that individual members of the Senate could filibuster a nominee, a prospective judge or justice, and require 60 votes to get a nomination to end debate and to actually vote on a nominee to the federal court. That has been ended in recent years, so now it just takes a basic majority to confirm a president's appointment. The stakes are high for both political parties when it comes to judicial appointments. Again, the judges and justices of the federal judiciary, they serve for life. They interpret the Constitution. The Constitution is relatively vague in areas and not particularly detailed. That gives a lot of power to members of the Supreme Court in particular to determine what the Constitution really means. Again, they serve for life, so the stakes are high. What have we seen in recent years when it comes to presidents and their ability to really leave a legacy behind when it comes to their appointments to the federal court and particularly to the Supreme Court? Well, President Bush had the opportunity to appoint 2 very conservative justices to the Supreme Court. One of them replaced Justice Sandra Day O'Connor, who was a swing voter. She was conservative in some ways, but more liberal in areas related to reproductive rights and abortion and so on. And so President Bush's ability to change to replace her with Justice Alito, who was very conservative on those issues, really pushed the court to the right. Obama was not able to have as much impact on the Supreme Court. He was able to appoint two women, Justice Kagan, Justice Sotomayor, and really diversify the court, both in terms of gender and ethnicity. But both of those justices replaced two left of center justices who retired during President Obama's time in office. So the balance of the court didn't really change that much. Likewise with President Trump, his ability to name two members of the Supreme Court, Neil Gorsuch and Brett Kavanaugh, both of those replaced conservative members of the court. Neil Gorsuch, however, Brett Kavanaugh, however, did replace Justice Kennedy, who was more of a centrist member of the court. Neil Gorsuch obviously was highly controversial because Justice Scalia died unexpectedly during President Obama's administration, almost a year left into it, and President Obama named a replacement to his vacant seat, and the Republican Senate, led by Mitch McConnell, did not take any steps to even have a vote or hold hearings on President Obama's nominee, which of course was highly controversial, very unusual, and a point of a great deal of acrimony between the two political parties. Some of this I've already explored, but partisanship plays a big role in judicial appointments, particularly the higher you go, the courts of appeals, the Supreme Court. The stakes are extremely high. About 20% of a president's nominees are rejected or not acted on, and Merrick Garland under President Obama was an example, and one of the more controversial examples we've seen in recent times. And depending on party balance in the Senate, if you have divided government, if you have Republicans in control of the presidency and Democrats in control of the Senate, or the reverse, it's going to be a lot harder to get justices appointed to all levels of the court, but particularly the Supreme Court. So President Obama was much less successful in naming members to the federal judiciary because much of his time in office was divided government. And also they were still operating under the rule that you needed 60 votes to confirm members to the federal judiciary, confirm appointments to the federal judiciary. So President Trump has been much more successful, has already over 400 appointees confirmed to all levels of the federal judiciary during his time in office. Consider a bit the background of justices on the Supreme Court over time, over American history, and how their demographic backgrounds differ from what you would see in the larger population. And of course, what you see is a disproportionate amount of people of the Protestant tradition, white people, only a handful of people of color, only a handful of women have served on the court, and just about all in recent years. A Supreme Court is known by its Chief Justice, so currently it's the Roberts Court. And since 2006, when Chief Justice Roberts was confirmed, the court has continued on a more conservative trajectory. They have ruled in favor of gun owners' rights, execution by lethal injection, and limiting Roe v. Wade. They overturned civil rights precedents in 2009, struck down campaign finance laws, and particularly the McCain-Feingold law that limited money in politics in 2010 and 2014. They limited, but ultimately did not strike down the Affordable Care Act, and Justice Roberts ended up siding with liberal members of the court to maintain most of that law. They have reduced the power of unions to organize and collectively bargain. One area where we've seen the court move in directions that maybe some wouldn't have predicted is that the Roberts Court has actually expanded LGBTQ rights when it comes to marriage equality, and more recently when it comes to equality for employment, that people simply cannot be fired or penalized just simply because of their LGBTQ status. Spend a good bit of time understanding ways in which our federal court system, and particularly the Supreme Court, makes public policy. And these terms in particular are important to understand, and they're going to come up on the final exam. First of all, the concept of judicial review. This is not granted anywhere in the Constitution. This was established by Marbury v. Madison and the Marshall Court early on, but this is the power of federal courts and ultimately the Supreme Court to declare the acts of government officials or government laws unconstitutional. And that's a great deal of power. So, a bill can go through the House, it can go through the Senate, it can get to the desk of the president, it can be signed into law. And even at that point, the Supreme Court has the power ultimately to say, no, this law is not constitutional. It will not stand. That's a great deal of power that we see in our federal judiciary and our Supreme Court that many other countries around the world do not give to their court system. This creates the heightened conditions for judicial activism. That amount of power essentially allows courts, if they wish, and the Supreme Court, if they wish, to make public policy and to take a broader view of the Constitution. Sometimes we see conservative judicial activism that will read more conservative policies into the Constitution, and sometimes we see more liberal activism that will read more liberal outcomes and policies into the Constitution. This term is often used as a critique of decisions that people don't like. They will say, well, that's an example of judicial activism. That doesn't accurately reflect the Constitution. You're taking too broad a view of what the Constitution says. Now, the opposite of judicial activism is judicial restraint. And just about every member of the Supreme Court claims they engage in judicial restraint, which is that they don't want to use judicial review if at all possible. They are going to defer to Congress. They're going to defer to the president when it comes to both crafting and administering law whenever possible. So you will hear this often during Senate confirmation hearings that appointees to the Supreme Court will say, well, I engage in judicial restraint. And again, we engage in a lot of debate as to whether or not we have an activist court or a court that's engaging in restraint. How does the other branches of the federal government check the judiciary? Well, first of all, there are executive checks, whether or not the executive will carry out a judicial decision. That's important. I believe it was Andrew Jackson who rather famously said, hey, the Supreme Court's ruled, let's see them implement it. The Supreme Court is not going to parachute into your neighborhood and implement their rulings. So you need the support of the executive branch. And of course, and as we already discussed, the president appoints. So there's a power there. Legislative checks, well, if a Supreme Court rules, they still need funding to carry out their ruling. If they're going to order court-ordered buses to desegregate schools, legislatures at the state or the federal level are going to have to approve the money to carry out that ruling, as we saw after Brown versus Board of Education. And sometimes they don't. The Congress can also start the process to amend the Constitution, and then the Supreme Court would have to apply that amendment to the Constitution into their ruling. Or you could just simply change a law that was overturned by the Supreme Court in order to line it up with the Supreme Court ruling. So the Congress could then reconsider a law and try to change it, try to get the same outcome, but deal with a court's ruling that determined that it was unconstitutional. Public opinion is also important. Sometimes the public itself ignores decisions. So we saw, again, rulings with regard to desegregation in the mid-1950s, but we still saw very segregated cities and very segregated schools well beyond that. And to some extent, we still see it today. So sometimes the public itself will not carry out decisions. because there is pressure for non-enforcement. And then, as I mentioned before, judicial restraint. To what extent do judges say it is my judicial philosophy to defer to Congress unless I have a really good reason and there's a real clear illustration that Congress has made a law or the executive branch has carried out a law in a way that is clearly in violation of the Constitution. So trying to defer as much as possible, and when the Supreme Court does make a decision, to rule as narrowly as possible on that decision, to focus on the issue at hand rather than something that is broadly applied. Okay, to sum up, American law is rooted in the common law tradition of stare decisis, or let the decision stand. The Constitution limits the jurisdiction of the federal courts to cases involving a federal question or a diversity of citizenship, and we've already explored that. The Supreme Court's decision to review a case is influenced by many factors, including the significance of the issues and whether or not the Solicitor General, who represents the President of the United States, is asking the court to take a case. Federal judges are nominated by the President and confirmed by the Senate, and they're appointed for life, so the stakes are high. Justices to the Supreme Court inevitably become policymakers because they are determining whether or not a law is within the bounds of the Constitution or not. And this power of judicial review, established by Marbury v. Madison, makes the United States Supreme Court ultimately one of the most powerful courts in the world. And here are your guiding discussion questions for the week. As with weeks before, one substantial original post and at least 2 responses to your classmates' post. We are flying right through, finish strong with class participation, and please reach out to me with any questions or concerns.